All right. Well, welcome everybody to the next episode of the Trucknology Podcast. I'm your host, Jeff Berlin. And today I have a really special guest. I have Cristina, pronounce your last name for me, Belaval?
Belaval.
Belaval. Okay. I'm sorry. I'm very bad with pronunciation, but I appreciate you taking the
No
time
worries.
to talk with us today. If you would give us just a little bit of a background on how you ended up in collection law. That's not something that everybody specializes in. I know everybody in specializes in a lot of different groups in law, and not a lot of people specialize in that kind of group, especially transportation collections. That's a much different type of a nuanced thing, but I think is very relevant to our listeners. So if you wouldn't mind spending a couple minutes telling us how you got there.
Yes, definitely. So I started practice in Puerto Rico. That was over 20 years ago, and I used to represent banks. So in 2016, my best friend moved over to Texas. He used to be the attorney for Carlos Correa, and he moved over to Texas, and he told me that the life here was much better than what we were living in Puerto Rico. The economy there was pretty stuck. So I packed my stuff and moved over. I didn't have to take the bar exam because after 10 years it was passed through. So I became admitted to practice law in Texas. But I continued to work for the banks in Puerto Rico. Then I don't know if you remember the Hurricane Maria came to
Yeah.
Puerto Rico. All the courts shut down, all the banks shut down. So I said, now I have to find myself a job here, which I did. I had the benefit of meeting my ex-employer, and he was starting this new firm. It was solely trucking industry. They represented mostly insurance company in private in PI cases and personal injury. So he told me, look, there's this niche in collections for trucking companies. If you want to run that department, it's yours. And I said, well, I used to represent banks. It can't be that hard, and it's not much difference. It's numbers. I'm good at numbers, so let's do it. And since then, I've been doing it for the past 8 years. The firm closed the collections department last year, and I started on my own. I had the benefit of taking all my clients, so it was great, and it's been uh, it's been really good. I'm very happy with what I'm doing right
That's
now.
awesome. That's awesome. What has probably been the single biggest transition, I guess, from banking into trucking? Because trucking is kind of a unique space. Not a lot of lawyers have a specialty in trucking because, again, it deals with all the lower 48, plus all the ICC rules, plus all there's still things in our network that kind of are stuck there from the periods of regulation back in the late 80s and early 90s. Some of that stuff still kind of resides in our legal system. So what has been your biggest hurdle in learning to transition from bank collections to trucking collections?
Well, so I had to sit down and study all the law, all the case law that came prior to I started working, and it's very niche specific. It was originally based on federal law, but then the states adopted it as common law, and it gives the trucking company so much leeway to collect from. You don't only collect from one party. You have the right to collect from multiple parties, so recovery is really good. It's even better than the banks scenario
I'll bet.
because banks, you have a lot of bankruptcy, but here if the broker files for bankruptcy or they go out of business, you can still pursue the shipper and the consignee under the bills of lading, which is great for recovery for the trucking companies.
Yeah, so that's one of the things that I bumped into numerous times in my experience over the last 20 some years in trucking is that when a shipper or whoever is responsible for paying the bill doesn't pay the bill, that means other people can be involved, right? So how does and it always looks like there's a double payment. The carrier really stands a chance of getting paid or having to. I'm sorry, let me say it a different way. Whoever is responsible for the freight could end up paying twice if they get involved with somebody who doesn't actually transfer the money to the end carrier, correct? So how does that
Yeah.
factor in, and how do you deal with that situation?
So that's what we do mostly. There's a lot of double brokering in the industry, and the law does favor the motor carrier. So if the motor carrier that actually hauls the load is not the carrier that the shipper or the broker hired, that carrier can go against the shipper and the consignee to collect that unpaid freight. And the reason is public policy. The trucking industry is the backbone of our economy, and they're small people that they need to get paid. If not, they can't work. So public policy recognizes that and allows them to collect from multiple sources.
Right. So speaking as a broker, I mean, we've been a broker for 20 plus years, and there's a lot of times where we have to engage with carriers. And of course, if there's something that goes wrong with the shipment and the carrier isn't obviously in line to get paid because there's an agent in the middle, how do those contracts with carriers help protect the actual shipper of the freight to make sure that they're not going to be in a position to have to pay twice? Have you had that experience much?
I have that experience, but because I represent mostly in the carrier side, we try to uh, twist it in a way that that shipper is unable to enforce that broker carrier agreement because they're not a party to that broker carrier agreement. The the case law is divided. Some courts find that if the language is such that the carrier waives the right to collect explicitly in the contract, then they cannot collect against the shipper or the consignee. Some other courts require that the purpose of the agreement itself is to benefit the shipper and the consignee. And if the shipper and the consignee can't demonstrate that the parties entered into that agreement with the intent to benefit them, then they will not be able to enforce that provision.
Got it. So if you're the carrier, what is your recommendation, or what kind of advice would you give uh, carriers that have trouble getting paid, or that are in a position where they're trying to get paid from a shipper or a consignee? What kind of advice would you give them up front to be able to prevent those kinds of collection nightmares?
So the most important document for the carrier and the shipper and the consignee is the bill of lading. So you have to make sure that the parties to the bill of lading are correctly identified. So if you want to pursue the shipper, that shipper's name must be in the bill of lading, and preferably they have signed it also. And if you want to collect against the consignee, make sure that the consignee signs the PO, uh,
POD?
POD, yeah. The
Yeah,
POD,
yeah.
yeah, exactly.
Okay.
Uh, so that's very important on the carrier side. If you are a shipper and you want to be released from liability, the Uniform Bill of Lading has what it's called a non-recourse provision, or Section 7. And if you sign that provision, then the carrier cannot collect from the shipper and must collect against the consignee. And if the consignee doesn't want to double pay, they have to execute the prepaid designation on the bill of lading. And the prepaid is not as strong as the non-recourse because it's an affirmative defense where they have to demonstrate that they actually paid for the shipment. If they don't have evidence of that payment, then they're still liable.
Got it. And a lot of people, again, I've been doing this for 25 plus years, and I've bumped into tons of people who think the bill of lading is kind of you also need it document, but they don't recognize just how important that bill of lading really is to protecting yourself in that transaction. So you're right about that. And so anybody that's in the shipper space or is going to be paying for transportation really needs to understand how a bill of lading works, because that is really, really critical. You also touched on the other thing that I think people make a lot of mistake is the POD. So if your carrier delivers and they get to the consignee and the consignee signs the bill of lading free and clear, how does that impede your ability to collect for like a freight claim or something that may come in later that could diminish the amount of that invoice that could be collected? If a consignee comes back with a freight claim, then they're going to say, well, I've got a freight claim, I'm not paying the freight bill. How does that help with your carrier situation?
Okay, so it depends on how the broker carrier agreement is set up, because in terms of that particular shipment, if the broker carrier agreement doesn't say anything in terms of setting off different claims, then you'll have problem collecting on that one, but they can't hold you responsible for other shipments that were correctly delivered. But a lot of broker carrier agreements do allow the broker to withhold payments on future invoices if there's a problem with one of them.
Okay.
So,
Now, is that generally a state guideline or a state statute, or is that more a federal guideline?
that is in the broker carrier agreement. It's the agreement between the parties.
Gotcha. Okay. So that
Yeah.
depends on how
So
you set that contract up initially, right?
exactly. And
Gotcha.
then in terms of factoring companies, for instance, if you have a factoring company that's the one that's collecting, they will step into the shoes of the carrier depending on what the agreement provides. But if the agreement doesn't say anything and the factoring company wants to collect, and the shipper constantly says, look, there was damage in the shipment, they can say, look, I gave you notice of the assignments, and anything that happens after you receive notice of assignments, you can't offset against me, the factoring company. And that's the UCC provides that release to a factoring company, which is great.
Gotcha. Yeah, that really is a confusing issue for a lot of folks because in the transportation space, there's obviously a lot of different players. You know, it started out where it was just simply a shipper, a truck, and a consignee, but now they've injected all these other things into it. Brokers are one thing, and 3PLs, of course, and then factoring companies and all that other kinds of transactions. So, I'm going to put myself in the broker shoes for a minute, and if I'm engaging with carriers and I broker a load to a carrier and he ends up double brokering that load, even though my agreement with the carrier says specifically no double brokering is allowed, and that to the consignee or the shipper, the broker is the last responsible party to pay the carrier. Should that really kind of help exclude some of that back and forth if the broker is taking the position of the carrier and says I will collect on behalf of the carrier and the broker doesn't get paid, but he still pays the carrier, he can still act as the carrier when it comes to filing a collection matter, correct, against the shipper?
Okay. So if there's double brokering, the carrier that actually hauled the load is going to go against the shipper. The shipper is going to say that the original broker breached the agreement with them because they gave the load to a carrier that double brokered the load.
Right.
So the shipper is going to seek that the original broker pays the other carrier, even if it's double payment. The carrier that hauled the load cannot go against the broker, the original broker, because there's no contract between the parties, but they can go against the shipper.
Right. Gotcha. Okay. Yeah. And that's one of the things we find ourselves kind of in a stuck situation occasionally as brokers, I can tell you. And again, we specify in a contract that they can't double broker, and we do everything we can to prevent them from double brokering. And if we catch them double brokering, we void their contract and we take them out of our approved carrier list and all that kind of stuff because we know it's a terrible practice. But do you find yourselves in a position very often where you're representing a broker who's done something like that, where a carrier double brokered a load and you're kind of stuck filling in the shoes of the broker to be able to collect? Does that happen very often for you?
So when the broker is collecting, they're not collecting, at least on my on the clients that I've represented, when I'm collecting on behalf of a broker, they're stepping into the shoes of the carrier that hauled the load and paid, and they paid. They're not collecting on behalf of the carrier that double brokered the load.
Right. Correct.
Yeah.
Okay. That makes sense. Yep. Now that carrier that double brokered the load, there's really not a lot of recourse there, is there, for somebody? So if a broker engages with a carrier and they double broker a load, there's really not a lot of recourse against that carrier. All you can do is not do business with them again, right? Because they almost put themselves out of the transaction as soon as they double brokered the load. They're kind of out, right?
Well, there's what's called MAP 21, and that's a law that differentiates the brokers from the carriers. And it says that carriers cannot broker loads. So if you don't have authority under law to be a broker, you can't double broker. And it does provide for civil penalties of I think it's $10,000 per violation, and the managers and owners of that company are personally liable for the damages suffered as a result of double brokering. So that's an alternative, but as you know, most of the carriers that double broker loads, they're fly by nights, and even if you get a judgment against the carrier and the owner of the company, collecting is going to be hard.
Very hard to find a lot of these guys that they tend to skirt the system and cheat it, and we're finding a lot of times where now they're actually going on and changing the address on the FMCSA's registration for an MC number, so that it looks like the fraudster is actually the one with the good MC, and they want the good MC has got a different address. So you really got to be super careful these days with the way
Exactly.
carriers cheat the system sometimes. And it's not, I'm sure I'm not saying it's everybody, but it certainly happens. It seems like at a more prevalent rate lately. We just seem to find a lot of these fly by night carriers that are cheating it.
Yeah, and one thing, both on the carriers and the broker sides, is that I recommend to deal with people that have been in business for some time, 2, 3 years, and they're reputable, and you know that it's your odds are in your favor. But now I see that there's fraudsters that are buying companies that are in business for that time, and then they do the same thing with those
Yes.
established companies. It's
So
so sad.
crazy. It just blows my mind that they do that. Yeah, it's crazy. So let's talk about bonds, because that's kind of been a weird thing over my career. It started out where, if you had a carrier bond, you could also broker freight. Then they switched it to where you had to have a broker bond specifically and a carrier bond specifically. What are the kinds of situations that you've bumped into in a collection where you actually have an opportunity to go against one of those bonds to help get your clients paid? How does that work?
So when I usually recommend the client to pursue the bond directly, because their chances of recovery are just like in a bankruptcy. You have a $75,000 bond for the broker, and everyone that has a claim against it can file a claim, and then the company is going to distribute it pro rata depending on the amount of your client. So that's something that's pretty simple, and I just give them instructions how to do it, and they do it directly with the bonding company. But if they don't collect in full, which is usually the case, then I go against the shipper and consignee for the remaining balance.
Got it. Well, what I've always found is by the time you find out that you can go against the bond's already been completely distributed, and there's nothing left. So that makes it a big challenge. Have you found that the bond
I think
amount is sufficient?
No, I don't think the bond amount is sufficient, but I think that a carrier, I know it's hard for every carrier to do it, but when you are going to deal with a broker, you should go online in the FMCSA webpage to see if that bond is active. Because as soon as it gets canceled, you have 30 days to file the bond claim, and if you don't file it within that time, you're out of luck.
Yeah. And the bonding companies are obviously very motivated to get it resolved as well. I
Yeah.
know, occasionally I'll get a call from our bond company, and it usually comes down to a carrier didn't send the invoice or something got missed in processing or something, and you can usually resolve it. It's those ones that when you call and they don't know anything about it, or that the bond's been used up, that your your heart tends to sink, and you realize you're not getting paid, and then things start to get really ugly. So let if I'm a carrier and I come to you and say, Christina, listen, I got these clients that are not paying me, or this client that's not paying me. What is kind of the timeline and process on how you get through that? And how long should I really expect to wait to get paid? Let's assume for a moment that the person responsible for their freight bill is solvent. But they're just not paying you for some reason. How does that process normally work? Does it end up in a courtroom, or do you guys end up negotiating? How does that normally happen?
Okay, so it's twofold. If you want to keep that client, my recommendation is don't send it out to collections yet. Do the best you can to collect from that client directly, and you don't have to go as far as threatening to file suit, but you can threaten them to refer it to an attorney for formal collections, or a collections agency. There are multiple collections agencies out there that also collect on behalf of the carrier. So just let them know that this is something that is that the law favors you, and when you send it out to the collections agency or to myself, they're not only going to pursue payment from you, they're going to pursue payments from your customers as well. So it's in their best interest to pay you now. Because once you take it out to the collections agency or to myself, that relationship is probably over.
That's probably true. And no customer likes to get a call that says the carrier is collecting on them and they've already paid the broker and now they're having to deal with a secondary carrier collection. That's for sure. Yeah. So what has been the biggest, what has been the biggest aha moment that you've had transitioning from banking in Puerto Rico to carriers in Texas? I mean, listen, there's no way that you're going to tell me it was just smooth and seamless. So what was the biggest, wow, this is really different kind of moment for you?
No, it is. It is very different. And in fact, there's also, when I represent factoring companies here in Texas, we're serving mineral wells, and I file mineral liens. And that is something that I would never have thought that I would do. That is very different. There's no wells in Puerto Rico. Yes, and you have 6 months from the service date to file a mineral lien.
Wow. Okay.
Yeah. So that is very different.
How often do you actually get carriers that you talk to or that you get an opportunity to talk with that you help set up kind of how their collection process works to kind of make it be better from the beginning? Because I know there are certain things that a carrier can do to ensure they're going to get paid or at least improve their likelihood of getting paid. What are some of the, if I came to you and said, hey, Cristina, listen, I'm going to start a new carrier. I'm going to have 100 trucks and I want to make sure that every time I send a bill out, I'm going to get paid. What kind of advice would you give me for setting it up in such a way to make sure that when I bring a non-paying shipper to you, that you got the best chance of collecting?
Well, you should have a written process both for how the intake for new customers should be. What is the information that you're going to gather from all your customers, and to make sure that they're operating, they're in business, and they're good companies to have as customers. And also, you should have a process for internal collections, and you should look at your AR at least once a week with your team and make sure that you're getting paid as things progress and that you're not letting that AR sit for a long time.
Gotcha. Yeah, that definitely makes a difference. Obviously, if people let things go for a while, then all of a sudden the knowledge of it, the emails, the correspondence, the communication gets harder to put back together, and now you're trying to piece together a forensic file instead of a collection file. It tends to get a little bit crazy, I imagine.
And as soon as the customer is not doing what they're supposed to do, if they promise payment that they're not paying, or they're not answering your calls, their phone no longer works, you're not going to keep that relationship. Just send that out to collections.
Yeah, that really is one of the most important things is frequent communication. I know our collection person is just an absolute bulldog and makes calls constantly, and anything that goes over terms, I mean, she's on it like that because if you don't, people just forget, and then it gets harder and harder and harder for sure. So what are some of the biggest mistakes that you see carriers make when it comes to trying to do their own collections? I mean, you're a professional, you've got training in this, you've been doing it for decades. But I say I'm a carrier. I think I can do it as good. What are the kind of mistakes that I could make as a carrier that could make it even that one that I'm probably not going to be successful, and two, you're going to make it harder for you if you actually do get that file and try to collect on it? What kind of things can I do that can make it harder on you that I shouldn't do?
Okay, one thing is not knowing the elements of the bill of lading and who can you pursue under the bill of lading, because you have a shipper that executed the Section 7 on non-recourse and you're pursuing them, then you're not going to be able to collect against that shipper unless that shipper doesn't know what that means, and it's likely that they know what it means. And the same for the consignee. If they executed the prepayment provision and you haven't asked for evidence of payment, then it's just the ignorance of what the document does for the carrier, the shipper, and the consignee. Another issue could be that you sue in the wrong jurisdiction or you pursue them in the wrong jurisdiction because this is interstate transport. Then you have to make sure that wherever you pursue them, you can sue that party. Because not because I'm in Texas, I can sue everyone in Texas. Texas may not have jurisdiction over that shipper or consignee that hired a broker somewhere else, even if
That's
the
a
carrier is from Texas.
That's a great point. As a matter of fact, thanks for bringing that up. So, we're based in Flint, Michigan. You're in Texas. We used to have a terminal in El Paso. If my client was in El Paso and I'm shipping something to Oregon, let's say, we're and my consignee's in Oregon, my carrier is in let's say Colorado, and my shipper is in Texas. What's the proper venue? I can, if I'm in Michigan, I can file a federal case to a certain point, but right? Or how does that actually work? How do I go after a company in Texas if I'm in Michigan?
Okay, so in terms of federal, there's no longer a federal claim jurisdiction for collection of freight charges. Now it has to be diversity of citizenship, and to sue in federal court, you have to meet the threshold, which is $75,000.
That's a lot of shipping.
Yes. So if you don't have $75,000 claim, then federal court is out of the question. You need diversity and the 75,000. In terms of suing in Oregon or California, or what was the other
I think
one?
I said Oregon, Texas, and I'm in Michigan.
In Michigan. Okay, so you can always sue the party in the jurisdiction where they're located, but you don't want to sue all of them in different jurisdictions. So you should sue them where the shipment was either picked up or delivered.
Okay. Does it matter which one?
No, not really. It could be either. Yeah.
Okay. Okay. I got to imagine that's always a challenge because you're dealing with a lot of state laws in addition to federal laws at some point, I guess, until you get over that 75,000 threshold. But is there an advantage in some cases? Are there certain states that are better for treating carriers better? I mean, I know it is more of a federal thing, but I also know certain state laws probably help a little bit. Are there certain states that are better or worse?
Yes. There are a couple of states that are very carrier friendly. For example, Texas is very carrier friendly. Indiana is very carrier friendly. Let me see what else. Pennsylvania is carrier friendly. Those are a couple of good jurisdictions that are carrier friendly. Yeah.
Okay. So if I'm a shipper and I've got a carrier that I didn't pay in one of those states, I'm probably better off to just pony up and move on, right? Instead of trying to fight them.
Yeah, and no, and there's nationwide collections companies that will do all of this for you. Like, I'm the local attorney for Baxter Bailey and Associates, and I do all their claims in Texas. But if there's a case that's not from Texas, I send it over to them, and they can sue it anywhere in the nation. So
Gotcha. Do you get a lot of referrals from other states where an attorney is maybe in Connecticut and he said, I don't really know a lot about Texas, but I'd like you to help me with this? Do you guys have a lot of,
yes,
is there a lot of that happens in the law industry or legal industry collection side?
yes, there is. Yeah, and
Have
I
to
do the
imagine.
same for them.
Gotcha.
Yeah.
Yeah, I got to imagine. So if somebody wants to reach out to you and say, Christina, I need some help. I don't know what I'm doing. What's the best way to get a hold of you?
So my email address is Cristina without the R, without the H, Cristina at freight-cs.com.
Okay.
And my webpage is freightcollectionsolutions.com.
That's awesome. We'll put
And
that
my
in the
phone
description.
number,
Yep.
yeah, and my phone number is 346-574-3483.
All right. Thank you for that. So what do you think about the freight business? You've been in it for about 8 or 9 years now. What is your opinion of how it works relative to how the banking side works? I mean, better, worse?
I think it's better. It's given me so much diversity in the people that I've met and the contacts that I've made over these years, it's been a great ride.
That's awesome. That's awesome. Well, listen, we thank you very much for your time today. Most of these episodes are 30 to 45 minutes. And so I appreciate all that feedback, and I'm hoping to not get a bill, because usually when I talk to an attorney, I get a bill. Just kidding.
You will not.
I'm just teasing. No, well, thank you very much. It's been good. And collections really is one of those weird things. I was the CFO of this trucking company for 20 plus years. And believe me, I bumped into a lot of collection claims, and I'm always, kind of tossed up. I mean, how can I go after this? How can I go after that? What is the advantages really of having a lawyer involved with those collection activities rather than trying to do it yourself? I mean, what can you really cut down the timing that it takes to get money in?
I would say that it's in your advantage. As long as you don't want to preserve the relationship, it's in your advantage to hire someone that knows what they're doing and knows where to collect. Because if you send it over to me, it's the percentage of collections is going to be much higher and much faster than if you do it yourself. It's I would say it's a no brainer, but you have to know that it's with a customer that you don't want to preserve the relationship, because I am going to get with their customers and it's not going to be pretty.
I completely agree with you on that, by the way. I can tell you probably 10 or 12 situations in my experience where as soon as we say, listen, we've done everything we can to negotiate with you. You're clearly not going to pay. I got to get my attorney involved. As soon as they make a phone call and say, listen, we recognize that you already paid the carrier. They double brokered and screwed you, blah, blah, blah. You're going to end up paying for this again. All of a sudden, the realization comes to them and they're like, it is what it is, right? So I can tell
Yeah,
you that there's been a lot of times where I've reluctantly handed it off to an attorney because I thought I've reached the end of my rope with it, and then for some reason the attorney gets it done in a week, and I'm like, oh, man, how did they do that? So I agree that there's definitely a reluctance to do it because of the fee, but I can tell you if you want to get paid, lawyers often know a way to just say it the right way to get a shipper to realize that, hey, it's the inevitable, so you might as well just write the check. So it
exactly.
does make a difference. And, in trucking, cash is king. If you're not getting paid, that, makes your job a lot harder for sure as a carrier, I can tell you. And most of our listeners are going to be brokers and carriers and shippers and like that. So this kind of a conversation is very helpful. So thank you very much, Cristina. It's been great to meet you. And, if we get an opportunity to talk again, I'd like to do that if you don't mind.
Thank you. Same here. Have a great day.
All right.